Counsel seeks permission to address the Honourable Bench as Your Lordship. Much obliged, Your Lordship. This is the counsel for the petitioner appearing in the matter of Minority Watch versus Union of Indica and others. Your Lordship, I am speaker number 1 representing TC19 and my co-counsel is speaker number 2. Your Lordship, if you're well versed with the facts of the case, may I move on with the issues? Indeed, Your Lordship. Your Lordship, there are 3 issues in this writ petition filed before the Honourable Supreme Court. The first issue is whether the present writ petition is maintainable before the Honourable Supreme Court. The second is whether the Prohibition of Illegal Conversion Act 2024 is violative of the fundamental rights. Third is whether the 108th Constitution Amendment 2024 is violative of the fundamental rights and the basic structure doctrine, Your Lordship. I will be dealing with the issues 1 and 2, that is the maintainability of the writ petition and the Prohibition of Illegal Conversion Act, Your Lordship. May I move on with the first issue? Indeed, Your Lordship. Your Lordship, the first issue is whether the writ petition filed before the Honourable Supreme Court is maintainable. Your Lordship, this is substantiated with 3 further sub-contentions. The first being that the petitioner has locus standi to file the present petition. Second, that the 108th Amendment Act is in violation of the basic structure and the Prohibition of Illegal Conversion Act 2024 is in violation of the fundamental rights guaranteed in the Constitution. And the third sub-contention is that the Honourable Supreme Court has the jurisdiction to entertain the current writ petition. Your Lordship, the first sub-contention that the petitioner has the requisite locus standi is that in this present case, it is humbly submitted that when there is a public injury occurred to a disadvantaged community of the society, any person with a bona fide interest or sufficient or genuine interest can invoke the writ jurisdiction of the Honourable Court under Article 32 to file a public interest litigation as in the present case, Your Lordship. It has been held in the case of Consumer Education and Research Society versus Union of India that any member of the public with sufficient interest with regard to a public injury that has happened to a member of the society, or a disadvantaged community of the society, can file a public interest litigation, Your Lordship. Further, the public interest litigation in the present case is real and in furtherance of public interest. It is not used to invoke any personal cause, political advance or any other consideration, Your Lordship. The petitioner in the present case is an NGO by the name of Minority Watch, who has a history of advocating for the rights of the minorities in the Northern Province, Your Lordship. With regard to the second sub-contention is that the impugned law is in violation of the fundamental rights enshrined within the Constitution. Your Lordship, with regard to the Prohibition of Illegal Conversion Act 2024 that has been implemented in the state of the Northern Province, it is humbly submitted that in the case of Bennett Coleman versus Union of India, All India Reporter 1973 SC 106, Your Lordship, the true test was the direct effect of the impugned state action on a particular fundamental right, Your Lordship. In the present case, the direct effect, with reference to the word direct and the direct effect, it means the quality of character of the said state action, Your Lordship. In the present case, following the 108th Constitution Amendment that omitted the words socialism and secularism, such a Prohibition of Illegal Conversion Act being implemented in the Northern Province has an adverse effect on the rights of the minority communities in the state, Your Lordship, with effect to their rights under Article 14, 15, 19, 21 and 25, Your Lordship. Further, with the insertion of the 108th Amendment Act into the 9th schedule, it means that the intention behind the 108th Amendment Act is to not subject it to the judicial scrutiny of the Honourable Court, Your Lordship. Since any law or act that has been placed into the 9th schedule will have an immunity of the 9th schedule that is subjected to judicial scrutiny. However, it has been held otherwise, as in the case of I.R. Koilo versus State of Tamil Nadu. In the present case, the intention of the respondents were to give it the judicial scrutiny under the 9th schedule by placing the same by following it with an amendment into the 9th schedule, Your Lordship. With respect to the third sub-contention, that is the jurisdiction of the Honourable Supreme Court extends to the violation of the present writ petition filed with regards to the fundamental right violation, Your Lordship. It has been held in the case of Ramesh Thapa versus State of Madras, Your Lordship, All India Reporter 1950 SC 124. It was held that the Supreme Court, being the guarantor and protector of fundamental rights, cannot refuse to entertain application seeking protection of rights, Your Lordship, which have been infringed. That is, the Honorable Supreme Court must entertain writ petitions in cases where there have been obvious violation of fundamental rights, Your Lordship, as in the present case. As understood from the Moot proposition, paragraph 19, Your Lordship, several minority communities were affected by the passing of the prohibition of illegal.
Before you proceed,
Indeed, Your Lordship.
so far as you had pointed out that this is a statute which has been included in the 9th schedule,
Indeed, Your Lordship.
wouldn't it become necessary for you to first explain out the maintainability of the petition itself?
Indeed, Your Lordship.
Because insofar as it has been included in the 9th schedule, there is a substantial restriction on judicial review. You did refer to one decision, but did not proceed to explain it out further. How do you substantiate the maintainability insofar as the relevant statute under challenge is already included in the 9th schedule is the question?
Your Lordship, with reference to the I.R. Koilo versus State of Tamil Nadu case, it was held that any amendment, any act or law that has been amended into the 9th schedule is subject to judicial scrutiny if it affects fundamental rights and consequently the basic structure doctrine of the Constitution, Your Lordship.
Is it regarding the inclusion part or regarding the contents of the statute?
Contents of the statute, Your Lordship. In the present case, the constitutional amendment has been amended further into the 9th schedule. This hasn't been previously done before, Your Lordship. It was only laws and other acts that were basically 9th schedule was to give protection to land agrarian reforms, Your Lordship. Primarily, this was the intention of the 9th schedule. However, further on, when there were other acts or other statutes that were added into the 9th schedule for the immunity of the 9th schedule that is given under the 9th schedule, it was held in the case of I.R. Koilo that such an immunity cannot be misused by the legislature to give the immunity that will subject it from judicial scrutiny, Your Lordship. Hence, the same has been challenged by mentioning again that the 108th Amendment is violating fundamental rights and the basic structure, which will be further illustrated by my co-counsel in issue 3. Indeed. Your Lordship, with regard to the same, the jurisdiction of the Honorable Supreme Court is invoked because there is a clear case of violation of fundamental rights, Your Lordship.
There is clear violation. Or else the violation is not so clear that only High Court has the power.
Indeed not, Your Lordship.
It is taken as together. You will have to distinguish the power of the High Court and Supreme Court, saying that when there is a clear violation of fundamental rights, the Supreme Court can intervene. If the fundamental right is not so affected,
Indeed.
there is not so clear, can it be so?
Indeed, Your Lordship. With regard to the case Karak Singh versus State of Uttar Pradesh, All India Reporter 1963 SC 1295, I would like to refer this.
What is it?
Judge, Your Lordship.
Please read the ratio.
Your Lordship, with reference to that, it was held that the jurisdiction of the Supreme Court can be invoked even if there is an alternate remedy in clear cases when there is a violation of fundamental rights, Your Lordship, which is clearly in this case. Your Lordship, in the present case, after following the 108th constitutional amendment, taking cue from the same, exactly after 1 month in the Northern Province, the Legislative Assembly of the Northern Province passed a bill named the Prohibition of Illegal Conversion Act, Conversion Bill 2024. Your Lordship, in the same, which is taking cue from the 108th Amendment Bill, Your Lordship, when the 108th Amendment Bill clearly removes from the preamble the words socialism and secularism. Further, it has further amended Article 25, Clause 1. It has inserted an Article 1A, which has made all the articles subject to the interest of national religion. Following this, when a Prohibition of Illegal Conversion Act is implemented in the Northern Province,
there is absolute bar for High Court.
Your Lordship, with reference to the same, we are challenging the Constitutional Amendment Act as well with reference to the
High Court is powerless.
Indeed not, Your Lordship. The High Court has wide powers, Your Lordship, more than the Supreme Court does.
This petition can be filed before the High Court also.
Your Lordship, with reference to that, since the Constitution 108th Amendment affects citizens of India.
Have you gone to the Supreme Court when the provisions of Pandemic Act was challenged before the Supreme Court? A bench of 3 judges, led by former Chief Justice D.Y. Chandraju, referred the man before the High Court and asked them to approach the High Court, then come back.
Indeed not, Your Lordship.
3 bench decisions.
Maybe not, Your Lordship. However, in the present case, as the 108th Amendment affects the citizens of Indica as a whole, Your Lordship, the same.
See, then the power is not available to the High Court.
It is, Your Lordship, with respect to the Prohibition of Illegal Conversion Act.
Do you agree that the power of the High Court as well as Supreme Court, in of 30 to 227 is parallel, is concurrent?
Your Lordship, with reference to the same, since we are challenging the Constitution 108th Amendment, following which the Prohibition of Illegal Conversion Act was implemented, there are the Prohibition of Illegal Conversion Act was implemented in such a way that it is subject to the interests of the national religion.
I put it this way: this petition is filed for the High Court. Can the High Court dismiss the petition saying that this is not valid? Only finding that the petition is not valid for the High Court. What is your answer?
It will be maintainable before the High Court, Your Lordship, because that is a violation of fundamental.
So you indirectly agree that this petition can be filed before High Court for our time. Yes.
Your Lordship,
That is why I specifically asked. The jurisdiction is concurrent. Yes.
Your Lordship,
What about the 9th schedule protection?
Your Lordship, with reference to the same, when the reason to invoke the jurisdiction under the Supreme Court is because when the Supreme Court's with reference to the Supreme Court's judgment, it acts as a precedent for the rest of the High Courts of Indica, Your Lordship. When it acts as a precedent for the High Courts, it ensures that such arbitrary state legislations such as the Prohibition of Illegal Conversion Acts are not implemented again in the other states, Your Lordship. Hence, the Article 32 is invoked under the Honorable Court, Your Lordship.
Not on Article 30. See, the protection insofar as an amendment made in the Constitution by including the same in the 9th schedule is to avoid challenge on that aspect. Whether the bar by including 9th schedule is absolute or it is subject to change, that is the decision we have referred. The decision says the distinction. That is asked by my friend also.
Your Lordship, with reference to the same, it is not absolute. When approaching the High Court, even if these two were held as not maintainable, I can still seek the judicial jurisdiction under the Supreme Court because there is a clear case of violation of fundamental rights. With regard to the 9th schedule, it is not absolute judicial scrutiny, Your Lordship.
Can you say that it is not valid for the Supreme Court?
Your Lordship, in the case it holds the same, I can still invoke the jurisdiction of the Supreme Court because I believe there is a clear violation of fundamental rights in the present case, Your Lordship.
What do you mean by clear violation of fundamental rights? For the subject matter dispute or the points to be discussed or something having a larger interest to be decided, which would affect the entire nation. Therefore, it is better to decide by Supreme Court. That is your point.
Your Lordship, it acts as a precedent, hence invoking the Article 32, which is in itself a fundamental right of the citizens, Your Lordship.
Yes.
Coming to this,
Removal of the word socialism violates the fundamental right of the citizen. In what way you can explain?
Your Lordship, it is submitted that socialism was inserted into the preamble in order to decrease the exploitation of the social workers at the time, Your Lordship, with reference to the 42nd Amendment. Socialism was inserted into preamble so that these workers, the exploited workers, were given their necessary protection, Your Lordship. They were exploited in such a way, especially the minority communities, Your Lordship. That is exactly why there are other articles that promote that is inserted in order to protect. Your Lordship, Indica is a welfare state, Your Lordship. With reference to the same, removing socialism from the preamble will subject further interpretation as preamble acts as an intrinsic aid of interpretation. Removing the same from the preamble will subject the further legislations from being interpreted in such a manner that the other communities, that are the disadvantaged communities, can be exploited, Your Lordship. Socialism, the meaning socialism, which when it was inserted, is to mean that Indica is a welfare state, or further to prevent the exploitation of the disadvantaged workers, Your Lordship. The word socialism is a huge concept, Your Lordship. However, at the time of inserting it, this was the primary issue. By removing it from the preamble will subject it further, the other communities, the disadvantaged communities, herein will be further exploited by the removal of the same, Your Lordship. If there are no further queries, may I move on to the second issue, Your Lordship?
Yes.
Thank you. Much obliged. Your Lordship, the second issue is whether the Prohibition of Illegal Conversion Act 2024 that was implemented in the state of Northern Province is violative of Article 14, 15, 19, 21 and 25. Your Lordship, this is further substantiated that it is violative of the said articles. So the sub-contentions are: first, it is violative of the articles 14, 15, 19 and 21. The second sub-contention is that it is violative of the fundamental right under Article 25, and further, religious conversions is encompassed within the right to propagate one's religion, Your Lordship. With reference to the first sub-contention, it is submitted that the right to equality has been declared by the Honorable Supreme Court as a basic feature of the Constitution, Your Lordship. The minority communities in the state currently are being faced unequal laws, Your Lordship, with the implementation of the said state legislature. When they should be receiving constitutional protection, they are being subject to the interest of the national religion, Your Lordship. Further, in the case of K. Timmappa versus Chairman, Central Board of Directors, SBI, year, All India Report of 2001, SC 467, it was held that when a law is claimed to be discriminatory for denying equal treatment, the court's task is to assess whether the differentiation has a just and reasonable connection to the law's objective, Your Lordship. In the present case, when the Constitution Amendment Act in itself seeks to protect the interest of the majority population, that is the Sindhuites, by subjecting every other recognized religions to the same, the implementation of such an statute will infringe Article 14 of the minority communities in the state, Your Lordship.
Why do you say so? Because there is an intelligible difference between these two categories.
Indeed, Your Lordship.
And the object of the statute is to address that difference which is already there.
Indeed, Your Lordship. Class legislation is prohibited. Indeed. With reference to the same, there is class legislation in the Scrutiny Committee that is composed by the said Act, Your Lordship. It composes of a district collector, a social welfare officer, 3 members representing the majority religion, the national religion, and 1 member representing all the other recognized religions, which consists of Podicists, Prophetism, Puritanism, and other tribal religions as well. 1 person is representing the same. Here there is a clear case of class legislation being provided in the Act in itself, Your Lordship. Further, in the case of Shira Banu versus Union of India, it has been held that a law which violates Article 14 is when it is manifestly arbitrary. From the said provisions, it is understood that the provision is manifestly arbitrary as it is marked by favoritism. Favoritism to
The amendment brought into Article 25, Class 1. Precisely what does it mean? The amendment.
Your Lordship, amendment of Article 25, may I read it out loud? Much obliged, Your Lordship. Subject to public order, morality, health and interest of the national religion and to other provisions of this part, all persons are equally entitled to freedom of conscience and the right to profess, practice and propagate religion. Your Lordship, with
Propagate which religion? Which religion?
Your Lordship, religion of their choice, Your Lordship. Subject.
Before amendment, the interest of the national religion was not there. 25, 1. But interest of the national religion is the addition. Correct.
Indeed, Your
Is that
Lordship.
correct? Then propagate religion. What religion?
Your Lordship,
Is it the religion prevailing in the country throughout, or the religion that is the national religion introduced with effects from amendment to Article 1A?
exactly what the council is challenging, Your Lordship, with reference to the same.
Please tell me what you understand from reading 25.1, 2, but 25.1.
Indeed, Your Lordship, with reference to the same, before amending the said article, it was subject to public order, morality and health and the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. Your Lordship, the said amendment has removed the word freely from it.
Really removed and the interest of the national religion
Is added.
Article 1A introduced Hinduism as the national religion.
Religion.
Then what is meant by propagate religion? to please give her 3 minutes time.
Your Lordship, propagate religion means when you talk about your beliefs or your faith in a way so that others are inspired by the same and you can bring them to your religion
My
or
question is not that. Propagate religion includes any religion
Indeed, Your Lordship.
or religion that is the national religion.
Your Lordship, with regard to the same, I would like to challenge this before the
For
respondents.
challenging, then you must specify what is the harm caused by this amendment.
Your Lordship,
If this provision is read, practice and propagate with an addition of any religion, then the freedom to do the same is still protected.
indeed not, Your Lordship. With reference to paragraph 11 of the Moot proposition, in the statement of object and reasons, the last line says to protect the interests and rights of majority population of the country, which means that with respect to the majority population, even if an act is implemented which does not include or neglects the rights of the minority communities or other recognized religions, it can be implemented if it seeks to approve, if it gets the approval.
Here case that because of introductory words in the amendment act, the word propagate religions to be read as propagate Hinduism religion alone.
Your Lordship,
You must distinguish. Otherwise, what is the scope of challenge?
Your Lordship, the right to religion is restricted by the interest of the national religion, which means that it is restricted. The right to
You
propagate
have
any
a case
religion.
that the word propagate religion is intended impliedly that religion should be Hinduism alone. Otherwise, what is the scope for challenge?
Indeed, Your
See,
Lordship.
in this question, by the amendment, interest of the national religion, that means against without affecting the national religion and its belief, anybody can profess, practice, and propagate other religion. That should have been the interpretation. Then what is to be challenged?
Your Lordship, the same is being challenged that other religion and freely has been removed. There is no other or any mentioned in the said article. Freely has been removed, which means
Do you have a case? That is I am repeating. Do you have a case there in Article 25(1)? Practice and propagate religion means the religion Hinduism alone. Is it intended by so? Otherwise, what is scope of challenge?
Your Lordship, I will stick to my second issue, which challenges.
Please. Suppose you read the unamended provision 25, wherein two words are absent, two clauses are absent. The first clause is interest of the national religion. Second is freedom of
Freedom of conscience.
provisions and right to profess.
Right freely to profess practice.
Because something is removed. That is not so material. But what is material is the introduction of the interest of the national religion after declaring that the national religion is Hinduism. Then propagate religion, free right to profess, practice and propagate. If the religion is other religions, what is prohibited is not to inflict or infringe upon the Hinduism religion, but otherwise they have these rights, profess, practice and propagate. Then why you are challenging this provision? That is my question.
Your Lordship,
Otherwise, you should have a case that by this provision, the legislature intended that apart from the Hinduism religion, no other religion could be professed, practiced, or propagated. There is a prohibition. Where is the prohibition?
Your Lordship, with reference to Article 1A, it shall be the duty of the Union and states to promote the national religion, Your Lordship.
Yes.
Therein it is established that the same.
Those who are professing, practicing, and propagating a religion is doing the same. Any religion.
No, Your Lordship, it has been restricted. The right.
Where is the word?
Your Lordship, when a rich, if I may give a practical scenario, Your Lordship, in the case if I have a ritual that is deemed to be offensive by the interest of the national religion, and I am doing the same without the approval of the said interest of the national religion, the same would affect their sentiments, Your Lordship, and I would be subject to the interest of the national religion. I could
So
be.
you have an apprehension that when any other religion is professed, practiced, or propagated, that could not be done without affecting the interest of the Hinduism. You have such an apprehension.
Indeed not, Your Lordship.
Otherwise, your challenge is
It is not an
perfectly not manageable.
it is not an apprehension, Your Lordship. With reference to paragraph 8, violence spread throughout the country to an extent affecting the security in itself. The minority religious places and government offices were looted and disrupted. Minority religious places were looted and disrupted. This is because the majority population felt threatened by the same, Your Lordship, with respect to conversion. However, they are alleging that
Since you are challenging two aspects. One is introduction of 1A and 25.1. Second, the continuation of that inclusion, the other statute passed by the legislature of the state. Correct.
we're also challenged.
So, your challenge is subject to challenge of 1A and 25.1.
And the preambular omission, Your Lordship, of the words secularism and socialism.
You please read 245 of Constitution.
Indeed, Your Lordship.
245. 24 or 45. Shall specify.
Extent of laws made by Parliament and by the legislature of states. 245 article.
No, 246. 246.
Your Lordship, shall I read it?
3. 246. 3. Read.
246 clause 3. Subject to clauses 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in schedule 7. Your Lordship, however, with respect to the northern province,
Even before the amendment, states power to legislate upon this matter is protected in list number 2, that is state list.
indeed, Your Lordship.
Can you imagine that no amendment at all? Whether the state legislature is wrong in passing the subsequent amendment
Your Lordship, with respect to the
to
same,
a particular act.
Your Lordship, we do not question the state legislature's competency to enact laws with regard to public order.
Enacting law competence otherwise,
Oh,
if the enact competence is a different question,
indeed, Your Lordship.
then the constitutionality of the provision is another question. So, even before amendment, the power is there.
Indeed, Your
Power
Lordship.
is
Power is there, Your Lordship.
then comes whether the amendment runs against the fundamental principles of constitution, including the basic structure. What are the basic structure defined in the Deshavandi Parties?
Your Lordship, secularism, judicial review, socialism, democracy,
Supremacy of the constitution.
supremacy,
That is the
supremacy
first
of the
one.
constitution,
Second is rule of law.
rule
Correct.
of, indeed, Your
Then
Lordship.
what you stated all. Correct.
Your Lordship, with reference to the same, can I submit two more compendiums?
3 minutes more.
Your Lordship, 12 states in the state of Indica has implemented anti-religion laws. Your Lordship, with reference to the same, there are mainly three features of every anti-conversion laws in the country of Indica. First is the prohibition. First is the provision of conversion provision. Second is the notice or a declaration given by the converting person, and the third is a burden shifting provision. Your Lordship, it is submitted with regard to all 12 states and all 12 of their acts. The same three have been included. However, in the present case, it is very arbitrary. With the formation of a scrutiny committee, they have said that the legal provision is ratified before the same, and they will hold approval of whether you have conducted illegal conversion.
As conversion as such is prohibited. All types of conversion.
All types of conversion, Your Lordship. There are two sections, section 12 and 30. The first is inducing illegal conversion. The second is illegal conversion itself.
Illegal conversion.
Illegal conversion. In no other states,
Imagine 1A 25 water.
no.
The state legislature passed the act now under challenge. Then the question is whether the same would pass the test of constitutional mandate within the principles of basic structure. If so, the the act introduced by the state legislation is hit by the fundamental principle, basic structure principle. Suppose by introduction of 1A and 25(1), is there any subtle difference in the matter of protection of fundamental rights otherwise?
Indeed, Your Lordship, with reference to Article 15, Article 19, and Article 21, Your
No
Lordship.
amendment for that.
No amendment for that, Your Lordship. Article 15 clearly says that there shall
Do
be.
you have a case that 25(1) introduced and also 1A introduced itself are unconstitutional because the same runs contrary to the principles of fundamental rights? That is your argument.
Indeed not, Your Lordship. It is subject to the interest of national religion. All these articles are being affected for in furtherance of the same. It is not just Article 25, Clause 1, Your Lordship. The omission, as I mentioned earlier, submitted the omission of the preambular words as well as the insertion of Article 1A, and in furtherance the communal clashes and the violence that erupted suddenly due to the organization Sindhuite Solidarity, who invoked such violence within the citizens of the state, merely through a rumor that there is forced conversions being held. However, Your Lordship, forced conversions is not something that we accede to in the same. With reference to the state legislature,
So please conclude in 2 minutes.
indeed, Your Lordship, with reference to the state legislature, section 13, illegal conversion in itself is an offence, Your Lordship. In no other 12 states of the country of Hindustan has conversion in itself become an offence, Your Lordship. However, in the present case, merely by ratifying before a scrutiny committee whose proportion is 3:1, 3 people representing the national religion and only 1 representing all other recognized or unrecognized religions, Your Lordship. With reference to the same, there is obviously a manifestly arbitrary authority who will misuse their power in furtherance of their objectives, Your Lordship. Further, religious conversion is encompassed within the right to propagate one's religion, Your Lordship.
Please read section 3(1)(a) of the Act the to place
Come then.
and not name the state. No person shall A. convert or attempt to convert either directly or otherwise any other person by use of misrepresentation. The first misrepresentation. 2. Allurement. 3. Use of threat. 4. Force. 5. Undue influence. 6. Coercion or marriage or by any fraudulent.
So voluntary conversion has not been interfered with this.
Exactly, Your Lordship. Voluntary conversion in the present case has been interfered with. In the said MP
That
Act,
is why we can proposition that fundamental rights to profess any other religion, even going by the amended provision, is not affected.
Your Lordship, it is affected, Your Lordship.
How?
Illegal conversion is
What
ratified.
is the right of a member of a religion to convert another man to his religion by using the methods I have already read?
Your Lordship,
These are all compelling methods. Is it legally permissible?
You
It is-
have every right to propagate, but you don't have the right to convert by using these illegal means.
Your Lordship, Section 12, we do not argue with and I accede to the same. However, Section 13 in the present, in the State Act, Your Lordship, that you hold, illegal conversion or voluntary conversion in itself is not made into a penalizing offence. However, in the said case, Section 13 penalizes a person up to for 6 months imprisonment and fine when he converts himself. In all the other state acts, the person who is converting another person, that is, it could be a church or an institution, it could be another person. When a person converts from one religion to another, there could be rituals that are being followed, Your Lordship. This is obviously guided by the person of the church or the institution that they are converting into. The person who does this through inducement, not the voluntary person that I could be converting, I am being penalized under the said section, said state legislature, Your Lordship. The other acts, the said person is not being penalized. It is only the person who is converting the other who is being penalized, and exactly why the intention and the whole state legislature is being challenged.
Time is over.
Much obliged, Your Lordship. It was an honor arguing before the Honorable Court.
Yes.
Your Lordship, I'm Speaker number 2 in Team Code 19 in the matter for the Council of the Petitioners in the matter between Minority Watch versus Union of Indica and others. Your Lordship, I shall be.
Place it down.
It's not very big.
Somebody will help her, please.
Just put it. I'm audible, right? Thank you. Your Lordship, I shall be dealing with the third issue regarding the 108th Constitution Amendment Act, and it is contended that it is violative of the Basic Structure Doctrine and Article 14, 15, 19, 21, 25, and 27 of the Constitution, Your Lordship. With reference to the Basic Structure Doctrine, in Keshwanda Bharati versus State of Kerala, the Honorable Supreme Court has observed that the constituent power under Article 368 does not confer the power so as to damage or destroy the basic feature of the Constitution. Your Lordship, moreover, the word amendment postulated that the old Constitution must be retained through in the amended form, wherein, Your Lordship, I would take this opportunity to submit my case compendium.
Thiruvananthapuram judgment was authored by how many judges?
Your Lordship, a bench of 13 judges.
Who are the judges supported this view?
Uh,
How many judges? How many opposed?
Your Lordship, in the ratio 7:6.
That means the Keshavananthapuram's case itself was rendered by a thin margin of one judge at 70.
7. 7.
Correct.
Indeed.
You continue. Yes.
Your Lordship. Delivering the leading majority judgment by Chief Justice Sikri, it was observed that only reasonable abridgments may be made to fundamental rights so as to adjust them to secure the directive principles, Your Lordship. And it was also observed that while maintaining the freedom and dignity of every citizen by Justices Hegde and Mukherjee, it was held that the dignity of individual secured by various freedoms and basic rights in Part 3 was also a basic structure. Moreover, clarifying the position in Indira Nehru Gandhi versus Raj Narayan, it was held that the ratio therein in the Keshwanda Bharati case was that not a specific feature is the basic structure, but as it should be determined by the court wherein a specific feature is quintessential to the structure of the Constitution. Moreover, with reference to tab 2 in my case compendium, there was another implied limitation on the amending power wherein an irresponsible despotic discretion governed solely by what is deemed a political necessity is not the constitutionally sound way to bring in a constitution amendment. Your Lordship, with reference to paragraph 8 and 9 of the proposition, it is provided that when it was observed that the Sindhuites had started not favoring the ruling party and was turning towards We the People party, the Supreme Command Bureau of the SNP party had called for a meeting with the Prime Minister and Cabinet Ministers and asked them to appease the interests of the National Regional Lordship, and it was consequently wherein this amendment act was passed. Hence, Your Lordship, this is an act of irresponsible despotic discretion, Your Lordship. Further, the Honorable Supreme Court in Minerva Mills vs. Union of India has observed that Article 14 and 19, which will be challenged in my next sub-issues, are the most elementary freedom to be preserved at all costs. If the discipline of the article is withdrawn, the political pressures exercised by the numerically large groups can tear the country asunder, Your Lordship. And further, in IL Koilo versus State of Tamil Nadu, it is reiterated that Article 21, read with 14 and 19, is the basic structure of the Constitution.
Please answer. No amendment. No amendment of the Constitution. As we are, Constitution stands as it. No law also. There is no law amendment by the state also prohibiting illegal compulsive conversion. Suppose X belongs to one brother, one religion, compulsorily make another wife to convert him to his religion. Is it otherwise justified? A compulsion.
It's not an offense. It's not an offense.
Your Lordship, if it is being induced, it is an offence as per existing.
By fraudulent means, etc.
Yes.
That
Indeed,
means not voluntary. That is the segregated word we have
Indeed.
referred. Then it's permissible.
Your Lordship, the person who is converting the other, it amounts as an offence. However, if a
It's
person
not only an
wants,
offense. It is indirectly infringing his fundamental right to go with the religion he has been professing prior to his compulsory conversion. Then there is, under the guise of protecting my fundamental right, I don't have the right to infringe upon another man's fundamental right. I do have the fundamental right to profess practice any religion. For the time being, I am believer of X. Then I am compelling Y to come to my religion, though he is voluntarily not ready, by some methods of various nature as we have read earlier. Then what we are doing, myself is doing, infringing the right of the other man and his fundamental right. On my claim is that I am protecting my fundamental right so that I can profess any religion. This is permissible without any amendment.
Your Lordship, the primary argument of the council is that with regard to a person who is converting by inducement, right, fear or bribery, that is indeed an offence and a violation of the other
The
person's
statute
fundamental
itself,
right.
section 12 says the same.
Your Lordship, however, the statute also calls for section 30, wherein a person who is converted by the effect of such inducement threat is also being penalized, Your Lordship. That itself is a violation of their
You
fundamental
already
rights.
said even without an amendment, doing the same is an offence, or else the same is affecting the infringing the fundamental right of the other man. Then, by a statutory sanction, when the same is penalized for providing imprisonment, what is wrong with it?
Your Lordship, I would like to reiterate that with reference to section 13, the person who is converted is being penalized, Your Lordship.
Converted.
Yes, a converted person is,
Penalized.
if it could not be ratified to the scrutiny
That
committee.
is not like that. The person who converts without following legal provisions, so that by this amendment itself, voluntary conversion is not prohibited. That is why it is stated legal provisions. As per the procedure established by law, that includes the fundamental right provided to him to profess his own religion or to change his religion. Then what is wrong?
Your Lordship, in section 12, it is the conversion, whoever conducts a conversion by such and so is being penalized. But Your Lordship, in section 3, the person who converts without following the legal provision was considered to have committed the offence of illegal lordship. The person who is converted is being penalized.
The conversion must be legal. Correct. Then
Indeed, Your Lordship.
your point is, when a person converts by the inducement of others, section 13 punishes him. Is it so?
Indeed, Your Lordship, the person who is being subjected to
The
such
person
conversion
who
is
converts,
yes, the person
who
who
is that
converts.
person? Who is that person?
The person whose religion is being changed.
The person who converts means, suppose A converts B into another religion. Whether the person who converts is A or B?
B.
B.
A
Correct.
is punished under section 12 and B is punished under section 13.
The person who converts, that is the wording. That is the word.
Who converts
So
their
the
religion.
converts is that is the phenomenon. A person converts. That means I compel X to go for another religion, for my religion. Then I am also converted. Suppose B also is doing the same converts. Then how can you say that that is pertaining to the person who is subjecting to conversion? Is the person to be punished?
Your Lordship, if there's a person A and B and
Otherwise,
A
there
is
the legislative vacuum. Legislative vacuum. The person who converts means what is intended in my understanding is the person who is doing it, who is compelling it is the person, not the person who becomes the victim of that compulsion. That is not like that.
Your Lordship,
So,
then
our
section
understanding of section 13 by reading the same is slightly in the opposite.
Your Lordship, section 12 is
The person who undergoes the conversion is
Yes.
not intended to be penalized here at all.
The point
All that it provides for is a mechanism so as to monitor the process of conversion. Whether it has been done, because even if these provisions are not there, any conversion by any means that cannot be termed as voluntary is illegal. All that this law has done is to provide a specific mechanism so as to ensure that what is already illegal is streamlined. That is all.
However, the council has interpreted section 12 as punishing the person who induces the conversion, and section
you have a suspicion that there is some sort of legislative vacuum in that area, some clarity lacking. The person who converts alone is taken and interpreted. Normally,
Lordship,
the interpretation should be to the person who is doing this compulsion, not otherwise. You can argue that if it is interpreted in a second thought, it may include the person who was compelled to convert. But the provision doesn't say so. That is fundamentally wrong also. A penal problem would not be for punishing the victim himself. Correct?
that is the council concedes with the same, and it is also noted that the Prohibition of Illegal Conversion Act was brought in the backdrop of the 108th Amendment Act, Your Lordship, which itself, by declaring the national religion, is not creating an unreasonable classification.
You could possibly say that the provision as such lacks clarity and it is capable of being misused.
Indeed, Your Lordship.
And it is hit by Article 14 in that sense.
In terms of being manifestly arbitrary, Your Lordship. Moreover, the composition of scrutiny committee will also come as an issue in such
So
a case.
the interpretation of a competent court is what I say. It is intended to punish the compulsion based on who made the compulsion, not to punish the person who is the victim of compulsion. What the point? And
Indeed.
also you have no worry at all. But you can apprehend a multiple interpretation so as to put the victim also under harm. Is it correct?
Your Lordship, the council also questions the relevance of presence of individuals from national religion and other recognized religion in the scrutiny committee. In the other acts which were submitted, the ratification was done by the district magistrate, but in this case, the legislatures involved nominated people from religious sects, and it was on the backdrop of this Constitution Amendment Act, which gives the interest of national religion.
Do you agree that suppose the amendment to 1 day and 25(1) in a way is treated as hitting the fundamental principle, that is the Keshavananthapuram's decision. Suppose those provisions are being declared void, then also House Act is void because of 246(3). This Act, how can it be void?
Because
You don't think that your question is because of introduction of 1 day and 25(1), using that freedom, this Act was passed with the legislature. 463 says otherwise the legislature has the power to decide to pass such laws. If so, your challenge today so far as the removal of secularism and introduction of a religious state may be treated as affection of fundamental basic structure of the constitution. Is it correct? In that way you may. Otherwise, even without that, the other state law is not prohibited.
it is manifestly arbitrary itself with regard to the the interpretation and
Please.
See, even if your contention that section 13 takes in the victim, there may be cases where the victim also participates in the crime and he may have the mentality about the conviction. See, for example, in corruption law, bribe giver is also bribe giver can also be punished in certain circumstances.
But your lordship, the right to choose one's faith is a fundamental right under Article 23.
But section 13 and 14 only different. See,
You answer one question. Please answer only one question. If a person voluntarily works for another religion, is there any prohibition, either in the amendment provision or in the statute? Any prohibition?
There is no explicit prohibition, but if their conversion is subject to the ratification of the scrutiny committee, and if the scrutiny committee finds that it's an illegal conversion, the person will be penalized.
There lies a point, because the appointment of a scrutiny committee, etc., are unwarranted. That is the thing. So, in a way, takes away the fundamental rights. So, those provisions otherwise not sustainable.
So, the section 13 itself is being challenged. The act in itself, in the backdrop of the communal violence and the attempt by the state to appease only the majority community itself is questioned.
Please. As per the question itself, one particular community, the majority community is correct. What the law says, compulsive conversion is prohibited. See, majority is having an upper hand. In fact, the law is against them also, because they can't also convert the minorities into their religion by compulsion. Then how can you say that this is arbitrary?
But your lordship, in
prohibition applies to the majority religion also.
the scrutiny committee, the 3 out of the 6 members are from the national region, and moreover, the government who is appointing these members are now being favoring the interest of national region.
The case of a person who belongs to Hinduism converts another man of another religion to Hinduism. Then whether he is an offender or not, any protection given to him, he must be also an offender. Correct. Then compulsion by any religion, whether it is majority, minority, whatever it may be, is prohibited, because to protect the freedom of religion, though as per the amendment, the constitution takes in Hinduism as the religion of the state, make this democratic country a religious country. Then also the other protection is there. If it is without those words, compulsion, coercion, then absolutely arbitrary.
But your lordship, with reference to the Article 25, which deals with the freedom of religion, your lordship, it is submitted in the present case. It is being subjected to the interest of the national religion, your lordship, and subject to means it's being subservient. The interest of other recognized religion is to practice their religion, and that too the word freely also has been removed, your lordship, is being subjected to that of the interest of national religion. Your lordship, with reference to doctrine of essentiality, it is determined by the honorable court whether certain religious practices come under as essential practices, and it is protected by Article 25, your lordship. If the language of Article 25 itself, wherein to determine the doctrine of essentiality, Article 25 to 28 is relied on to. If the language of the article itself is changed, your lordship, it will have a huge effect on the future of
that is why I think they were counted for a direct question. Do you apprehend misuse of this word, interest of the national religion, as a weapon, so that the minorities' right to propose religion will be affected? That's a question. Your counterpart answered negative. Your argument seems to be supporting such apprehension, because subject to public order, morality, health, then interest of the national religion. So a priority is given to the national religion.
Yes.
So you may have an apprehension that priority would affect the rights of the other minority religions. So it is arbitrary, that is against the basic structure, over which there may be interference.
Moreover, Your Lordship, there are precedential cases such as as held in Ismail Community versus Union of India, wherein it is provided that there is no state religion, Your Lordship, while recognizing a national religion, the mandate of secularism as interpreted by the Indian courts is being violated, Your Lordship.
Finished. Anything more?
Summarily, my arguments are concluded.
Please
Lordship.
answer. When the Keshavanandi judgment was delivered, on which date?
In 1970,
Date.
date, apologies, Your Lordship.
We will have to remember always.
24th April 1970.
23rd
April 1970.
correct. Should be in mind, because your entire case rests on only one case. Prior to there are other cases, such as Sequel, so many cases. Followed by the same final case. What is the last judgment on this basic structure principle?
Your Lordship, with reference to secularism and socialism.
No. What is the last judgment rendered by the Apex Court with regard to basic structure of?
Your Lordship, after Keshavanda Bharti case, Your Lordship, in IR
and to go around wisdom. You must have your own wisdom to answer these questions. When you are getting slips, that is, we may call it as borrowed wisdom, means the wisdom of another. What about the last decision?
Your Lordship, further basic structure doctrine has been discussed in.
Slip and answer. What is the last judgment?
In the slip, it's provided as IR Koilos State of Tamil Nadu in the year 2007.
2007. What is the National Judicial Act, Judicial Commission Act, and the judgment delivered will Supreme Court? You are not aware.
Your Lordship, with
JLC judgment is not in short form. That is, striking down the National Judicial Commission Act passed by the Parliament by the Supreme Court, not in 2007. Yes.
Lordship, I would just like to add one more case and I'll conclude my argument.
These are all matters you must bring into bear in mind while dealing with the subject of this case. Yes.
I'll just submit one final case and I'll conclude my arguments, Your Lordship. With reference to the word socialism and secularism being in the preamble, Your Lordship, recently a judgment in Dr. Balram Singh and others versus Union of India and another. Citation 2024 Indian Supreme Court at page 893 has upheld that the petition challenging the inclusion of social and secularism is dismissed as it's already part of the basic structure.
That is not a conclusive point. Because the judgment what was considered by the Supreme Court is whether the duty of the Supreme Court remains. See, there is a constitution. 368 is there. Parliament has the power to amend the constitution. Then, instead of doing the same by the legislature, while the Supreme Court takes into the power of the legislature to amend, delete, etc., that is not the duty of the Supreme Court. That is why that judgment. That is not upholding the principle of one basic structure. So otherwise, I am very much aware of this.
Much obliged, Your Lordship. Shall I move on with the prayers? Therefore, in light of the issues raised, arguments submitted, and the authorities cited, the counsel for the petitioners do hereby humbly pray before the Honorable Supreme Court of India that it may be pleased to adjudge and declare that the present writ petition is maintainable under Article 32 of the Constitution. The Prohibition of Illegal Conversion Act 2024 is constitutionally invalid and in violation of Article 14, 15, 19, 21 and 25. And Your Lordship, the Constitution 108th Amendment Act 2024 is violative of the basic structure of the Constitution and Articles 14, 15, 19, 21, 25 and 27 of the Constitution and or pass any other order direction and relief that the Honorable Court may deem fit in the interest of justice, equity and good conscience. For this kindness, the counsel for the petitioners do hereby duly filed for it.
Which writ would you seek for granting this prayer? Which writ?
Your Lordship, the writ of mandamus.
Yes.
Much obliged, Your Lordship. Thank you so much for this opportunity.
Greetings to the honourable bench. Is the council audible, or do you want me? Much obliged, Your Lordship. This is the counsel for the respondents in the case of Minority Watch versus Union of Indica. The council appears before this court to contend two issues that have been raised. Whether the Prohibition of Illegal Conversion Act 2024 is constitutionally invalid on the ground of violation of fundamental rights, and whether the 108th constitutional amendment can be claimed unconstitutional as it violates fundamental rights and the basic structure doctrine. Now, the counsel for the respondents will argue for both of these issues in the negative sense. I will be taking 20 minutes, while I'll be taking 20 minutes for the first issue, for the Prohibition of Illegal Conversion Act, while my co-counsel will take the same amount of time for the Amendment Act. If your lordships require a brief facts of the case, may the counsel proceed with the same?
No, you need to explain facts.
Much obliged. You want me to explain the issues? Much obliged, Your Lordship. However, before the council goes into the issue, the council will humbly submit that the present petition is not maintainable before this honourable court, Your Lordship, under Article 32. That is because in order to invoke this Article 32, there must be a violation of fundamental right and locus standi for the same, both of which will be proved to not be there as the council moves ahead with their arguments. And secondly, the alternative remedy under Article 226 have not been availed by the petitioner's lordship. The High Court has both writ jurisdiction where fundamental rights can be enforced and even constitutional rights can be enforced, your lordship. And in the case of Lokesh Katara versus High Court of Gujarat, the Supreme Court in that case refused to entertain a writ petition under Article 32, saying that the petitioners had a remedy available moving to the High Court under Article 226, Your Lordship. If the Lordships are content, the council would like to submit the compendium for the same.
When there is 226, the party cannot directly approach people.
No, Your Lordship, that's not what the council is contending. But in the present case, Your Lordship, the cause of action, where is it arising? In the northern province. Because the petitioners are alleging that people have approached them saying they have been wrongly accused of converting, of doing an offence under this act. So, if that is the first cause of action, shouldn't they be approaching the High Court?
No, their course of action basically from the amendment of the Constitution, which would affect the entire country.
Your Lordship,
that is the main cause where supplementary law was enacted.
Much obliged, Lordship, but the council would like to reiterate by saying that even this amendment, it has the power to be struck down by High Court.
I put it another way.
Your
You
Lordship,
say that now the Supreme Court decided to hear on the constitutional validity of the right to worship act.
yes, Your Lordship.
Worship places and decided no High Court, no petition, no decision. Then that is wrong.
Your Lordships, the council is not saying that what they did is primarily wrong, Your Lordship. The council is saying that they have this remedy that is available before the High Court.
Why not Supreme Court refer back to the High Court?
Yes, Your Lordship. Your Lordship, I don't
is formulated. They decided to hear the man and decide. Then no reference back.
Your Lordship, the council was submitting that the first cause of instance, because it was in this northern province, they should have approached the High Court. Now, the council would be happy to oblige if we can come back to this after we move on to the issue, if that is
And
permissible.
approach is whether the High Supreme Court is barred from hearing a petition directly without the intervention of the High Court.
Yes, Your Lordship. But
Or is yes or no?
Your Lordship, could you repeat your question?
Then appropriate is when a party approaches the Supreme Court and files a petition directly, whether the Supreme Court is powerless to entertain it.
Uh, Your Lordships, the Supreme Court is never powerless.
Answer must be with regard to the explanation I have already given.
Your Lordship, the Supreme Court is never restricted. We are just telling that they can exhaust their remedy under Article 226. Why? Because the facts of the
Exceptional circumstances in which they would get directly, we can still
when there is a proven violation of fundamental right, Your Lordship, and that would require what the facts of the case.
There is no such difference. But the Supreme Court's discretion is in two ways. One, in some cases, according to facts and circumstances, Supreme Court can prefer the party practice High Court. In
Yes, Your
some
Lordship.
cases, considering its particular nature, Supreme Court has the discretion to continue the proceedings. There is no absolute.
Yes,
That's the legal procedure.
much
So
obliged,
in
Your Lordship.
sanctioning of the matter, filing of this petition before the Supreme Court is legally permissible. Correct.
Your Lordship, while the council is understanding what the Lordship is putting forward, the council would like to prove that there was no violation of fundamental rights in their further grounds.
That is a different question.
Yes, Your Lordship.
That is an independent question.
Okay,
That is something conducted to the merit of the matter.
noted, Your Lordship.
Other is procedure for the difference.
Noted, Your Lordship. Noted, Your Lordship. May the council argue on the grounds, Your Lordship? Much obliged. So, the council for the respondent submits that this act, the Prohibition of Illegal Conversion Act, which will be referred to as this act, Your Lordship, is constitutionally valid and aligns with the fundamental principles enshrined in the Constitution of India. Now, I will be proving this in 5 grounds. The first ground being that it is consistent with Article 25. Your Lordship, let's analyze Article 25. What does Article 25 grant the citizens? Right to profess, propagate, and practice their religion. Now, nowhere in this is there included that they have the right to convert someone under Article 25. Now,
You understand the term profess
Your Lordship,
and propagate.
Your Lordship, the difference between profess and propagate is as simple as, let us say I belong to the Sindhutva religion, Your Lordship. If I am propagating this religion, that would mean I am claiming that my religion is superior, you should join it, and it will benefit you in this way. I am directly telling it to a second person. Whereas professing is me claiming,
It's practicing. It's like practicing the tenets of the religion.
yes, practicing the tenets of the religion, Your Lordship.
When would this propagation part graduate into an inducement?
The propagation part would graduate to an inducement when I am forcibly propagating this to an extreme extent, Your Lordship.
Acceptance remains with the receiver.
Yes, Your Lordship. And the receiver is not giving me that acceptance, yet I am still forcing them for this. Much obliged.
will note some inducement. See, in the propagation, there may be component of inducement.
Yes, Your Lordship. There is a
Will it not lead to, some way inducing by deceptive means a man from one religion to another?
yes, Your Lordship. Inducement does include that, and essentially, this promulgation that Your Lordships have so kindly put forward for the council is also inducement, Your Lordship, as I am trying to get their acceptance through hook or crook.
Then what is meant by the use of the word practice, propagate religion in Article 25?
Your Lordship, by practice, I can even stay in my home and practice my religion, Your Lordship. No one would know about it. But let's say I go,
Your answer to the word propagate is different. I am claiming supremacy over my
yes, Your Lordship.
and saying that the other man not to join my religion, which is supreme. That is the word meaning you have given. When the question is asked regarding the word, that word is aptly important. amended provision. In fact, that was there in the previous provision. Then,
Yes.
how can you punish? Only the right to propagate is protected. At the same time, now making the same by using some synonyms in other forms as punishable. How?
Your lordship, are you asking me how it is punishable if I do?
You please answer from the explanation for the word you have given for the word propagate.
Propagate. Okay.
Propagate includes some sort of inducement, as my senior friend already put up, to join my religion. If propagation is protected, propagation of one religion, a person who believes is protected, then how? By using some synonyms of the same word, making it as compulsion and punishment can be provided.
Your lordship, that is because the synonym in question is inducement. So the fine line of
Inducement. You have certain other words also like 13 and 12 and 13 of the disputed enact.
your lordship, okay, even considering those words, in that circumstance, even if the person that I'm trying to get to convert, they accept, then it is wrong on my part. But let's say I'm just simply propagating. I'm simply saying that my religion is good, you should join. And if they accept it in the first instance,
Should you may
yes, your lordship,
join or you should join.
you may join. You may join.
You have to tell it should.
Your lordship, the council would like to amend their pleadings for the word may. Your lordship.
Okay. Yes.
Much obliged about this. So, in the landmark case of Reverend Stainsla versus State of Madhya Pradesh, this is on 1987 page 25, paragraph 25 of the company lordship, the apex court had held that while the right to practice and propagate religion is fundamental, it does not include right to forcibly or unfairly convert others to lordship. Now, when I propagate my religion, it is up to the other person whether to join or not. It is giving the freedom, giving the people freedom to practice, profess, and propagate. That is, there is a liberty in giving it to them, not forcing, like not giving them the liberty to force their religion upon others. Even in the landmark case of Sarla Muddal versus Union of India, which is page 28, paragraph 45, it's in 1995, the court held that by the freedom of religion, my freedom of religion, does not extend to cause any acts that are harmful for any other person's civil or material freedom. And this civil and material freedom is harmed when one is forcibly converting the other person into their religion. Inducement. If your lordships are satisfied,
Have you read the constitutional discussion by the constitutional committee?
yes, your lordship.
What are the major discussions there? Because at the time of division, another form of one form of the country split up into another religion, and they are just religious state.
yes, your lordship.
But the remaining part of the now you are calling by the name Indica decided to go for a non-religious country. That is a majority of the discussions. So the legislative intent, the matter of constitution itself, basically, is that the country shall continue forever as a country where no religion has its supervision.
Yes, your lordship.
So, amending one day by shall be national religion of secularism is something that goes against the principles of basic structure and also goes against the entire discussion by the Constitutional Assembly. So, right there, so many days on each and every word. So, can we ignore those discussions made by very intelligent people to protect this country to be a non-religious one, giving freedom to all religions and keeping this country as a democracy. Other movements subsequently are.
Yes, sir. So, your lordship, the respondents are not ignoring the learned minds that drafted our constitution. We are not ignoring that all religions must be respected, all of them must be given equal rights, Your Lordship. It is without ignoring this that this amendment has been made. Even in the amendment, we are not saying anything that might denote that the other religions must be put down. Further explanation as to why there is a national religion will be developed by my co-counsel, Your Lordship. If Your Lordships are satisfied with that, may I go on to my second ground? The second ground of my argument is this Act does not discriminate and it upholds right to equality under Article 14. Your Lordship, this Act is consistent with Article 14 because it grants equality and there is an absence of arbitrariness and discriminatory classification. There is an intelligible differentia that has a rational nexus to the object that is sought to be achieved by this Act. Now, the intelligible differentia in the current case is the appointment of the conversion scrutiny's members. The nexus behind it is to make sure that the conversions that are taking place, they are not induced, they are not out of threat, and they are not bribed conversions, Your Lordship. In fact, it was in the case of D.S. Nakara versus Union of India, which is page 7, paragraph 11.
What is the basis for this intelligible differentiation? When there is a classification, what should be the basis of this classification so that each of these categories could be treated as different? So, before you rely on this intelligible differentia factor, you will have to explain as to what is the basis of this classification.
Yes, Your Lordship. So, the council would like to explain what the basis of this classification is. So, Your
You
Lordship,
are banking on it. You are banking on that there is a classification. And as far as Article 14 is concerned, it does not prohibit a classification. And unequal persons can be treated unequally.
yes, Your Lordship.
Now, you have to explain as to what is the basis of this classification.
Yes, Your Lordship. So,
And
let us.
how are they different? And is the classification rational and reasonable? That is also this.
Yes, Your Lordship. So, the council would like to elaborate the objective of the Act. Now, if I could direct your attention to paragraph 16 of the proposition, Your Lordship, it clearly outlines the objective of the Act, which is to make sure that there is no illegal conversion, and that is no conversion is done out of any threat of fear or any bribery, Your
Or
Lordship.
which the amendment is absolutely necessary.
Yes.
In order to pass such a legislation by the state legislature or by the central legislation itself, whether the
Moreover, stringent punishment provide.
Your Lordship, so the council would like to submit that this Act, it is not entirely out of the amendment. Yes, the amendment did play a role in it. But if I could direct your attention to paragraph 6, line 6 of the proposition, Your Lordship, it talks about how there have been instances or how there have been a possibility of neighboring countries, like that Your Lordship so kindly mentioned, that the neighboring countries pumping money to convert the people that are in Indica, Your Lordship. Now, should we not protect the integrity, the sovereignty of our nation? Should we not even protect the citizens who are being bribed, threatened, and they are doing it out of fear? So, it is for the protection of the citizens that we have enacted this legislation, Your Lordship.
When it comes to the question, sir,
how can you prevent that act?
Yes, Your Lordship. So, to prevent that act, to prevent what is illegal,
The country is a very fragile country and we have all the powers to restrain anything, any impact by means of direct influence or by introduction of money in a way make the situation malignant.
yes, Your Lordship.
Instead of working like from a different religion. See, I have to go through all these procedures. Will it not affect the privacy of an individual?
Your Lordship, the council would like to submit that it would only affect the privacy of the individual.
See, after preserving is a fundamental right.
Yes, Your Lordship, and the council agrees with that. And what we are extra, like, yeah. Yes, Your Lordship.
Or whether as per the Respondent speech, secularism feels declared as a basic right. So,
Your Lordship, so in order to like,
this answer was put it first. When you read the Thiruvananthapuram speech, you understand that the word secularism also is categorized as one among the basic structure along with so many that I always said supremacy demands rule of law, then secularism, and other aspects. Then how can you legislate against that principle where the conscience will fall where other means?
Uh, Your Lordships, so upon reading of the Keshavananda judgment, like your Lordship pointed out, secularism is proved to be, by the Keshavananda Bharati judgment, it was proved to be a basic structure of the constitution, your Lordship. But has the state not been helping the minorities too all this while? Has the state not enacted the Jharkhand Freedom of Religion Act, the Karnataka Protection of Right to Freedom of Religion Act, where even in those instances, to answer your Lordship's question of the privacy of the individual being in danger, even in those instances, if the person wants to convert, they'll have to inform the state and get approval and then only convert, your Lordship. And we are not asking a lot from the citizens. We are just asking citizens.
My senior brother had put that question very clearly and specifically. Secularism is a basic structure.
Yes, your
You
Lordship.
cannot tinker with it.
Yes, your
By
Lordship.
the statute, you are trying to do that. How do you justify it?
Your Lordship.
You cannot explain it out by saying that protection or preference or some convenience is being given to others. That cannot. Question is very direct and clear.
How do you justify deletion of civil?
Yes.
Because, your Lordship, it is affecting the
After 40 years.
because of the sole reason that it is affecting the national security of this country, your Lordship.
Say that secularism is a threat to the national security.
No, your Lordship. The second. No, your Lordship. Secularism is not threatening the national security. It is that people being threatened for this is affecting secularism, which my counsel will also elaborate upon fully as to why secularism.
Elaborate on this organization. Suppose your house is being occupied by some rats and you are under threat of the rats. What is the methodology you should have to adopt? You will have to find devices to send the rats from the house, either by removing or by killing. Correct.
Yes, your Lordship.
Is there any method to put fire on the house so that the entire structure, including the rats, will be destroyed? Whether this is a common sense approach.
Your Lordships, the council agrees with what the Lordship says, but the house is not being set on fire here, your Lordships. We are simply asking people to enter the house after the rats have been evacuated. Is it wrong of the state to ensure the safety of the citizens so that they aren't bit by these rats when they go inside their house? Let us remove the
The
rat.
foundation of the house is being taken away. The foundation is secularism. That is why we call it as a basic structure. That is a fundamental and foundation of the structure as such. That is being taken away. Wouldn't the house collapse? The superstructure cannot remain if the foundation is taken away.
Your Lordship, that's why, and we are not taking the foundation away. We are not only sending away select people from the house. We are not removing only select persons of the minority community. We are still promoting it, and the council will then further elaborate upon how it will be added to the preamble later. But for now, for the time being, your Lordship, the people who are in danger of being converted, who are in danger of having their secularism being snatched away, who their freedom of religion being snatched away, we want to protect them, your Lordship. And in order to protect them, we will need religious expertise. Do we not, your Lordship? Do we not need
How
to?
will you explain this word? Subject to public order, morality, health, and interest of the national religion. How? How the same is possible? One person is given the freedom, right to profess, practice, and propagate religion, but that is subject to public order, morality, health, no issues. But the third one and fourth one, interest of the national religion, which is declared as Hinduism. How can he profess? So, by introduction of these words, the other rights indirectly taken away.
Your Lordships, would it be acceptable by your Lordships if that specific question is answerable by my co-counsel as they have an entire ground on the same and their main issue is also on the same.
Yes.
So, if it is acceptable for your Lordship, coming to the matter of if I can just conclude my remarks about Article 14, Your Lordship, the Council would like to quote the state of West Bengal versus Anwar Ali Sarkar, where the court acknowledged that the state has the authority to define classifications for the purpose of legislations, particularly when addressing societal issues. Now, from this,
What is the criteria for doing so?
the criteria for doing so must be that
Is what?
intelligible differences.
Intelligible differential we may call it by another way. That should have been reasonable
Reasonable nexus.
exceptions, not otherwise.
Yes,
Should
Your
have
Lordship.
a reason.
Yes, Your Lordship.
Digestible prudence.
Uh,
Then continue. Yes.
Yes, Your Lordship, and there is a reason, Your Lordship, for this entire Conversion Scrutiny Committee too. Now, there has been a misconception that this Conversion Scrutiny Committee is the adjudicating body, Your Lordship. Now, the Council would like to pose a question before this court. If a doctor has a patient come in and they see injuries that they know is most likely being inflicted by some other, is it not the duty of the doctor to inform to the police? It is, Your Lordship, and
that takes to the next concept which you relied on, because you didn't rely on it. Proportionality.
Yes, Your
The
Lordship.
doctrine of proportionality.
Yes, Your
The
Lordship.
reasons that you have stated here, is it proportional to, or the reasons that you have stated for the enactment of these statutes or for the amendment of the Constitution, is it proportional to the
Yes, Your Lordship. Because this Conversion Scrutiny Committee is not adjudicating. It by itself is not sending people to jail, Your Lordship. It is more procedural in nature than adjudicative. And once the process works in a way where you will first need ratification from the Conversion Scrutiny Committee, as mentioned in the proposition, Your Lordship.
Then
And
please read 17, paragraph 17. 17 of the proposal.
yes, Your Lordship. Paragraph 17. The Act provides for the creation of a Conversion Scrutiny Committee in every district.
Committee
Consists of district collector, social welfare officer, 3 members of the national religion nominated by the government, and 1 member from the
national various religious organizations of national religion.
Yes, Your Lordship.
What are national religion?
Your Lordship, in this case, the national religion is Hindutva, Your Lordship. Yes, sir.
So the committee itself is with a dominating power over other religions. So no justice to be expected from this committee, because that committee, if your suppression is correct, national religion is Hinduism alone. If you are saying that national religion includes all religions included in 1A, then Hinduism is one religion. Prophetism, Puritanism, Motism, tribal religions. So, apart from Hinduism, 1, 2, 3, 4 categories.
Yes,
So, the committee will be represented by 3 into 4. That means 12 members from the minority community and only 3 members from the Hinduist community. Then your committee seems to be a committee which gives more representation to the minorities. This is so.
Is the Lordship,
National religion means only Hinduism.
Your Lordship?
Absolutely, that is intended is Hinduism alone.
Yes, Your Lordship.
Then giving representation for them in large number and giving one membership to the land.
One from the minority.
The one member from among minority community nominated by the government. That class 4 gives indication that national religion is Hinduism. Then what is this committee? The committee is a majority committee which intended to supersede the desires of the other members, and therefore what they say is the decision. It may not be always on justice, equity, and personal science as guaranteed by the Constitution.
So, Your Lordship, the Council would like to reply to that in a twofold manner.
Yes.
So, first, let's talk about the numbers, Your Lordship. Now, let us say there are 5 people who elect 2 or 3 people to represent them somewhere, and there is another set of 10 people who are selecting 3 or 4 people even to represent them. Now, it would seem that the 10 people are selecting a larger number of representatives. But your lordships, when we look at the proportion, when we look at the ratio of the people who are voting and the people who are selecting them,
Discrimination. 3 members to the majority of the community and 1 member for the other community. Why?
because in
At
that
least that manner, the proportionality should have been made.
the proportionality
3 members want.
the proportion your lordship, the proportionality is maintained because in the northern province, in the state of northern province alone, there is a sizable number of prophetism, Buddhist and other religion. So when there is a sizable number of them, it would only be correct to allocate 3 members of the national religion. Let us say they are a minority, we are happy to oblige them.
Limits the limits. What is described there? Hinduism plus 5. Correct.
Yes, sir.
Then which is another?
Your lordship, did you mention Hinduism plus 5?
5 religions also there. One day.
Yes,
True.
yes, yes. Lordship.
Oh.
No. The council did not understand. That's why, your lordship, it is fair for another reason, your lordship. At the end of the day, these members, they are there because someone needs to give in their religious expertise, your lordship. Now we must note that from district to district, the minority will differ. But what will be consistent is the sizable number of the minority.
Minority community may not differ according to district. Minority communities being classified generally throughout the nation. It's not otherwise.
Yes, sir.
For the purpose of the statute, even otherwise.
Your lordships, but in this case, the members of the national religion, they alone can provide insights into matters regarding their faith that can help the committee understand the context and implication of the conversion. Your lordship, let us assume that the majority community was not even play here. Let's say they are not even present and only the minority is there. Even then, whatever is coming before this committee will end up in a wrongful conviction.
See, the mode in which a decision is to be taken is not provided here. So the normal principles may come into play. What is the normal principle? Every decision of the committee shall have to be made on the basis of majority.
Yes, sir.
As done in the Keshavaranta Bharat's case also.
Yes, sir.
There 6 judges said otherwise, but 7 judges said the reverse. That is the law. But
Yes,
why?
sir.
Then this is the format of the committee. The intent behind the legislation is absolutely arbitrary.
Your lordship, the council would like to contend that alone by the lordship because when we observe other schedules of the constitutions that are providing a community to govern themselves, we can look at the 5th and 6th schedule of the constitution that gives tribal people the right to govern themselves through TACs. TACs, your lordships, that is composed primarily of tribal members who can advise the governor themselves for the matters of welfare and advancement of the people.
Tribal members and scheduled castes, etc., are fraction of the religions Hinduism. Then how will you separate among them?
That too, but your lordship, these tribal castes,
Hinduism is the religion.
yes, sir.
Where we may find several diversions.
Yes, sir.
Scheduled castes, tribal people are those on the backward side in the same category. So there
Yes,
is no classification in between them.
Definitely,
We are dealing with classification from the religion in 1A.
yes, sir. Lordship.
Now tribal people, etc. So 5th schedule, 4th schedule has no appeal. Have no appeal.
So, your lordships, if we have to deliberate upon these 3 members, we also have to consider their role. Do we not have to, your lordship? Their role in this case is that they won't veto whatever is the decision of the scrutiny committee. They are not there to overshadow the deliberations of the district collector and social welfare officer.
Veto. What do you mean by veto?
By veto, your lordships, I mean that they are giving their vote in such a manner.
Veto is a word has widest ramification. It's not a word we can use so simply to object.
Yes,
To
your lordship.
object is absolutely magnificently different from the word veto. Once the word veto is used, no further movement is permitted. It should be stopped there. Any such power here.
Your Lordship, then the council would like to reframe their argument to use another word instead of veto, where they are overpowering the council's decision by using the means of vote, Your Lordships. So that won't happen in this case because they are only taking into consideration whatever the contextual insight is, Your Lordships. And ultimately, the final decision is made by people who have acumen for the same, which is why we don't believe that
How
this
much
is.
time do you want?
Your Lordships, if I can just have enough time to give my last round of submission in a very short manner,
How
which
much
is,
time?
just 5 minutes, Your Lordships. Much obliged, Your Lordship. So, the last round of the council's argument would be the protection of vulnerable communities from exploitation and the reasonable restrictions on privacy and personal liberty under Article 21. Your Lordships, the council submits that this act addresses the legitimate public purpose of preventing fraudulent and coerced conversion